All right, good afternoon, everyone. Are you able to hear me? Thumbs up if you can. Can you hear me? All right, good afternoon. I am Judge Melanie Williams. This is the State Expedited Accusations calendar in the State Court of Fulton County, Georgia. This calendar is for those individuals who have been recently arrested for the cases that have already been formally accused by the Solicitor General and bound over to state court. All participants, this proceeding is being broadcast over the internet as a live stream. It's also being recorded. That means that any member of the public can log on and watch court today. All defendants, please pay attention. You have an absolute right to remain silent. Anything you say regarding the facts of the case can and will be used against you. You also have a right to an attorney here today. I see that there are some announcements regarding medical resets and someone being upgraded to felony. Are there any other announcements regarding resets or medical resets at the jail?
Yes, Your Honor, for position 4, that case has been upgraded to felony. However, I was informed that the defendant is a medical reset for today. However, I have submitted the order to transfer for Superior Court for Your Honor's signature.
All right. And position 7 has been reset medical. Any other positions reset medical?
No, Your Honor, but the state does have an additional announcement.
All right.
Your Honor, we have a case that came on our radar. It involves a Mr. Christopher Scott. It apparently, which is his booking number is 2211005. Apparently, he was booked in as though it were a felony case. However, it is a misdemeanor. Normally, we would just ask that this be moved to tomorrow and we can address it tomorrow. However, he will run Riverside after today. I have spoken to PD Kim. She is ready to proceed. We are just in a waiting status because we cannot actually accuse the case until it's unlinked from its PF number. So hopefully we'll get that done very quickly. I've already talked to the jail and they are working on that. And so once that's completed, we will go ahead and work up the accusation as quickly as possible so it can be addressed today. Thank you.
All right, Ms. Falk, I'll have to defer to whoever is assigned probably for that case number and the date of the offense because I don't have that before me, but that should be fine.
I am in contact with Mr. Jordan and he is assisting us. Thank you.
Thank you.
2 more quick announcements, Your Honor. My apologies. Position 2, to my understanding, is a pro se plea, and to my understanding as well, position 1, the defense would like a breakout room.
That's correct. Good afternoon, Your Honor. How are you?
Oh, good afternoon. Good to see you, Mr. Bartel.
Yeah, good to see you too.
All right, so position 2 is going to take the plea pro se. Has the paperwork already been prepared so we could send that to the jail? Because what I don't want, I would like for that paperwork to be signed and submitted back, or at least completed at the jail, such that we can get it back before the conclusion of the calendar.
Well, it's a pro se plea, Judge, but I did scan a blank plea form, and if I get an email address, I can send that to whoever at the jail can give it to Mr. Bray to fill out and sign.
Yes,
All
Your
right.
Honor, as well. I've also completed the paperwork. I'm just waiting on notification of who to send it to.
Can someone at the jail tell us who to send it to so that we can get it back for the end of the calendar and then we're not holding for that paperwork?
Nora's going to send his information to Bartel.
Okay, thank you. I appreciate that. All right.
I'll just keep an eye on my email.
Okay, if you put it in the chat, perhaps, Mr. Bartels, that might help. All right, we requested a breakout for position 1. Can we do that position first? I'd like to take all the breakouts first, if possible.
That's fine. And I think Ms. Kim wants to join us as well for that, Your Honor.
That's fine. Ms. Kim is welcome.
As well as Deputy Falk.
Okay.
Thank you, Your Honor.
Okay, so Judge, is you, Bartel, is Mr. Bartel's coming in breakout?
Yes, ma'am, I am.
All right,
Okay,
before you do it, let me read him. Ms. McLeod is indicating that she needs to speak with position 9. So someone at the jail could let her speak with that position while we do the breakout. And let me,
medical reset, Judge.
you said position 9 is a medical reset?
Yes, ma'am.
Okay, I was asking that earlier. Are there other positions at the jail that will be medical reset?
Is it?
I think number 4, Your Honor.
Yeah, I have 4 was up upgraded, 7 is reset, and 9 is also reset.
And 9. Okay, I got it.
All right. All right. Mr., are you Alan Boyce? Is that the position we're doing now?
Yes.
Okay, Mr. Boyce, your case number is 22 CR 004917D, in which you're charged with criminal trespass with the offense date of July the 26th. Do you understand your constitutional rights?
Not really, but
Okay, you have a right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney today at this proceeding. Do you understand that?
yes.
All right. If we could be placed in that breakout, Ms. Miller Brooks, it'll be me, Ms. Duncan, Ms. Falk, Mr. Bartels, and Ms. Kim.
Okay, Your Honor, give me one moment.
All right, thank you. All right, at this time, Mr. Boyce is gonna receive $1,000 surety bond. He is to undergo evaluations as discussed in breakout, and he must also stay away from 72 Marietta Street, have no weapons, drugs, or alcohol, or further violations of Georgia law. Is there anything further from either the state or the defense as it pertains to this case?
Nothing from defense.
Nothing from the state.
All right, best of luck to you, Mr. Boyce. Who do we have next?
We got position 12.
Okay, are you Prince Toria Salter? Can you pronounce your name for me?
Victoria Salter.
All right, Miss Salter, I'm Judge Melanie Williams. Your case is 22 CR 004942E, in which you're charged with 1 count of disorderly conduct and 1 count of obstruction with the offense date of July the 26th. Do you understand your constitutional rights?
Yes.
You do?
Not right now.
All right, you have a right to remain silent. Anything you say can and will be used against you. You also have a right to an attorney here today. Do you understand that?
Yes.
All right, Mr. Howard. Mr. Howard, if you're speaking, we can't hear you.
Can you hear me now?
Okay, we can hear you now. Thank you. The history.
2019 interference with government property and interference with government property and battery out of Douglas County. They were dismissed.
Okay, thank you. All right, whose case is this for the state? Oh, Mr. Dudley, it's good to see you. All right, what is the state's position?
Your Honor, this incident took place at 2119 Fairburn Road in Atlanta on July 26, 2022. Officer A.K. Echols responded to the location to investigate a disturbance. The defendant and the victim, Tariq Wilson, spelling for the first name is T-A-R-I-E-K-H, common spelling for the last name Wilson. They both spoke with the officer, giving their sides of the story concerning the disturbance. Mr. Wilson told the officer that the defendant had continuously caused problems at the home and that the neighbors had called about the disturbance concerning fighting. The defendant told the officer that Mr. Wilson had active warrants and that he was abusing her. The officer checked Mr. Wilson's history and did not find any active warrants. During the interaction, the defendant stated that she would have to go to jail and reached down to pick up a small brick. She began moving toward Mr. Wilson with the brick, stating, "You was not right." Officer Echols and Officer Trick both grabbed the defendant before she was able to reach Mr. Wilson, and she dropped the brick. Afterwards, she began to struggle and refused to comply with the officers. And when they told her to put her hands behind her back, and she was charged with disorderly conduct and obstruction of law enforcement. Your Honor, it's unclear if the defendant and the victim live together, but it does appear that they have a romantic relationship. And the state would recommend a $2,000 surety bond, the breakdown of that being $1,000 for the disorderly conduct and $1,000 for the obstruction of law enforcement, with the condition of no further contact with the victim and to stay away from the incident location. Nothing further.
All right. Thank you. Before I go to Ms. McLeod, I'm going to sound for the alleged victim, last name Wilson. Mr. Wilson, if you are present on this Zoom conference and wish to be heard, this is your opportunity to do so. All right, hearing none. Ms. McLeod, please proceed.
Yes, Your Honor. My client is 21 years old. She is not employed right now, although she tells me she's actively seeking employment. She has not graduated from high school, but intends to pursue her GED. She's working on it at this time, Your Honor. My client is currently pregnant. She was quite distraught, and I spoke to her because she tells me that she has not been given anything to eat in jail, and she has not been given any medical attention, and she is not feeling well. She also says that the officers who came to the location, they slammed her to the ground and mistreated her. So she was still crying about it at the time. She said she and the father of her child, who is the alleged victim, were just having an argument at his grandmother's house. They do not live together, Your Honor. I just want to put that on the record. They were both at his grandma's house, and they got into an argument. It was just an argument, and someone must have called the police. The police came, and they essentially manhandled her. So she's still distraught about that, Your Honor. The court will note that she has no history. Yes, she was previously charged with something, but that was dismissed. So she does not have a record. Based on that, I would ask the court to give her a signature bond so she can get out of jail and see to her health and to the health of her unborn child. Thank you, Your Honor.
All right. At this time, Ms. Salter is going to receive a $4,000 signature bond through pretrial, broken down $2,000 each charge. She is to have no further contact with the alleged victim, last name Wilson, and stay away from the location on Fairburn Road. She must also complete a one-day anger awareness course and have no alcohol, drugs, or weapons as a condition of that signature bond through pretrial. Is there anything further from either the state or the defense?
Nothing from the defense, Your Honor.
Nothing from the state, Your Honor.
All right, best of luck to you, Ms. Salter. That'll conclude your case. I would like to go back to the plea case if possible to make sure that we get the paperwork signed before the end of the calendar. Could we go to position 2 for the pro se plea?
Yes, Your Honor. I sent that paperwork to Officer Norris.
I emailed it a few minutes ago as well, so.
Was it received at the jail?
Yes, the paperwork received, they got time for him, the defendant to fill out the paperwork.
Okay, can I take the plea and then he fill it out so that his case will actually be closed by the time? What I'd like is to have that paperwork back by the time, before the calendar is over, if possible, to make sure it actually happens.
Right. Go to blue checks. You want to do him now?
Yes, please. That's what I'd like.
Can I get the bond amount for the last defendant?
Yes, it's 4,000 signature through pretrial, broken down 2,000 for each charge.
All right.
Okay, Mr. Bray, your case is 22 CR 004924C, in which you're charged with 1 count of fair evasion and 1 count of criminal trespass, each with the offense date of July the 26th of 2022. Do you understand that you had a right to an attorney today, but you're choosing to represent yourself?
Yes, ma'am.
And you understand you have a constitutional right to remain silent. Anything you say can and will be used against you.
Yes, ma'am.
All right. Ms. Duncan, if you'll briefly give us the factual basis here and also put the state's offer onto the record.
Yes, Your Honor. The factual basis is this offense occurred yesterday on July 26, 2022 at the North Avenue MARTA station. While working at plainclothes detail, and Officer Smith observed the defendant in this case, Mr. Jesse Bray, pushed through the closed fare gate without attempting to pay the $2.50 fare that is required by MARTA. In addition, it is notated in the warrant that this defendant did have a previous active MARTA suspension with the effective date of July 15th, 2022. As a result of this incident, the defendant now has an additional 30 days for violating the current suspension, which with a new effective date of September 13th, 2022, and the resumed date is October 13th, 2022. In this case, Your Honor, the state is recommending 12 months to serve, 2 days, credit for time served, 2 days, balance suspended with a stay away from the incident location, which is the North Avenue MARTA station located at 641 West Peachtree Street in Atlanta. Nothing further.
All right. Mr. Bray, you understand that if you take a plea today, that you can't go back to that station, that North Avenue MARTA station, But you should not have any additional time to serve in the Fulton County Jail. That's what you'd like to do?
Yes, ma'am. And the only reason I did what I did.
No, 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 don't say too
I
much.
just saying because I'm homeless. That's the only reason I went through the gate.
All right. Now, you won't have any additional time to serve. I'm gonna ask you some questions to make sure you're voluntarily taking a plea today, okay?
Okay, ma'am.
Please raise your right hand. Do you swear and affirm the testimony you give today for the limited purpose of taking this plea will be the truth to the best of your knowledge and under the penalty of perjury?
Excuse, what do perjury mean?
Basically, you get in trouble for lying under oath.
Oh, yes, ma'am.
All right, you can put your hand down. Did anyone force or coerce you into taking a plea today?
No.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
Are you under the influence of any drugs or alcohol that might affect your ability to understand what's happening today?
No, ma'am.
And you realize that this is gonna, you're giving up your right to a further court date on this by pleading guilty. You're not gonna be able to present any defenses you may have had to this charge.
Yes, ma'am.
All right, and you're giving up the right to have the state prove these charges against you beyond a reasonable doubt?
Yes, I don't be understanding some of the words, but yes, ma'am.
Okay, if you don't understand, if you do have a right to an attorney, you do not have to take this plea today, Mr. Bray.
Oh, no, I get it. Yeah, I take it.
Okay, so Ms. Duncan just gave us a set of facts. Do you agree with those facts and say that this case happened exactly the way that she indicated it did?
Yes, ma'am.
And was it actually you? Were you the properly identified victim? I mean, defendant in this case?
Yes, ma'am.
And did this case take place in Fulton County?
Yes, ma'am.
All right, and you are giving up your right to go to court later on this?
And as you saying that, what does that mean? Like giving my rights up not to go to court?
If you plead guilty, that's the end of this case. You've pled guilty. It's going on your record. Okay, and you understand you can't go back to the North Avenue MARTA station, correct?
I'm walking down the street.
Yes or no, sir?
Yes.
You cannot go back there. All right. As to the charges of fair evasion and criminal trespass, how do you plead, Mr. Bray?
Guilty.
And you're gonna complete the paperwork and sign that and send it back to give it to the people at the jail, correct?
Yes, ma'am.
Without any further problems.
Yes, ma'am.
All right, if you don't have other holds after you sign and complete, you should be released shortly, all right?
All right, thank you.
Best of luck to you, Mr. Bray. Don't go back there.
Next case, position 3.
Okay. Good afternoon. Are you Juan Carlton?
Yes, ma'am.
Mr. Carlton, your case number is 22 CR 004929J, in which you're charged with 1 count of simple battery, family violence, and 1 count of obstruction, each with the offense date of July the 26th. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard.
I counted about 20 total between Georgia, Illinois, and Indiana. Last arrest was 2016, possession of a narcotic drug, possession of marijuana that was out of Illinois.
Okay.
It must be all. Hold on. 2012, I got a battery arrest out of Markham. See, on aggravated unlawful use of a weapon, vehicle, possession of a firearm. Some of those says bond forfeiture judge, the other one says non-prosecute. It's a lot of counts.
Okay.
Also out of Indiana, dealing cocaine, 2016, 2016, invasion of privacy, 2015, possession of an altered, I guess, ID plate for a car. 2011, possession of cocaine. 2010, failure to appear. That's it.
Okay. All right, Ms. Duncan.
Yes, Your Honor. These incidents are alleged to have occurred yesterday on July 26, 2022 at 1224 D4 Village Court. That's DEFOOR Village Court Northwest, apartment 109. In this instance, Your Honor, officers responded to a physical altercation call. And according to the warrant, they had previously responded to that location. And they were met with the victim in this case, Ms. Lakendra Thomas. That's LAKENDRA Thomas, common spelling. When Ms. Thomas spoke to officers, she notated that when she left the apartment to go to the pool and get her son, when she arrived back home, she was locked out of the apartment. When she was finally able to get inside, Ms. Thomas told officers that the defendant in this case, Mr. Carlton, began getting loud and yelling in her face. At that time, he grabbed her by the neck with both hands, and then once he took his hands off her neck, he grabbed her by both arms and pushed her outside of the apartment. Once additional officers arrived and they approached the defendant in this case, he attempted to walk away from officers while they were speaking to him. However, he was stopped from walking away because the officers blocked both sides of the breezeway to prevent him from moving away. He continued to yell and bang on the door once he was outside speaking to officers towards the victim in this case. And additionally, once officers were attempting to arrest him, he resisted arrest by continuing to struggle and had to be grabbed by two officers on scene in order to have his hands placed behind his back and for him to be placed into custody. Given this, Your Honor, we have a concern about the risk of reoffense in this case. This occurred about 8:30 p.m. last night. We are concerned that there's no sufficient cooling off period in this case. We also have somewhat of a concern that this defendant is a flight risk because there is an FTA in the record. We did get a chance to speak to the victim in this case. And she stated that she is leaving the apartment. She wants no contact with him. However, she needs some time to get her things. Given this defendant's history, the facts alleged, and the other factors present in this case, the state is going to be requesting a $3,000 total surety bond. That's $2,500 for the simple battery family violence and $500 surety for the obstruction. No further contact with the victim in this case. A stay away for the state is going to request a 10-day stay away to allow Ms. Thomas time to get her things out of the apartment. 1-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. It is our intent that the victim said she's leaving. So once that 10-day period is over, we would ask that the defendant be returned with a law enforcement to ensure that she's left. Nothing further from the state. And
All right, thank you.
I think
go ahead, Ms. Duncan.
I'm sorry. I think the victim was on the line. If Your Honor would like to sound for her.
I always do. All right, at this time, I'm sounding for Ms. Thomas. Ms. Thomas, if you would like to be heard and you're present on the screen, you're not required to make a statement, but if you'd like to, please unmute your screen. Is Ms. Thomas present? Sounding for Ms. Thomas. All right, if Ms. Thomas does not wish to make a statement, we'll go to you, Mr. Bartell.
Yes, Your Honor, thank you. I have spoken with Mr. Carlton about this case. He does dispute the allegations in the warrant, and of course, he does enjoy the presumption of innocence at this point in the proceedings. He did confirm to me as well what the state had said, that Ms. Thomas is leaving or is not coming back to that location. There are no plans for them to live together, and he indicates that she is moving away to his knowledge. So a no further contact provision would not be an issue, Judge. There is a hold on him, so we're not sure what's going to happen with that. So if he posts a bond, we would just ask that police accompany Ms. Thomas to the residence. Because in the event that he is there within the next 10 days, He is employed full-time. He indicates to me that he's self-employed. He runs a branding and marketing company. And again, he does deny the allegations here. So based on all of that, we would ask for a $2,000 total bond, a $1,500 amount on the simple battery, and $500 on the obstruction.
All right, thank you.
Your
Ms.
Honor,
Thomas, I see that you're on the Zoom conference. If you'd like to speak now, this is your opportunity to do so, even though you're not required to. Ms. Thomas, do you wish to make a statement?
Hello,
Do you wish to make a statement, Ms. Thomas?
can you repeat that?
I said, do you wish to make a statement? You're not required to make a statement, but if you wish to, this is your opportunity.
Yes, what was,
Okay.
I couldn't hear the officer prior to what you just said.
I'm sorry. This is about your chance to make a statement. I'm not going to have him necessarily repeat what he just said, Ms. Thomas. The question I have is, what would you like to tell the court at this time? And do you wish to have contact with the defendant in this case? If you do, and you wish to make a statement, please raise your right hand.
Yes,
Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
yes.
All right. What would you like to tell the court at this time? And again, most interested in whether you wish to have contact with the defendant.
Yes, the no contact is no issue. I'm actually out of the apartment, so that's fine. I have no problem about that at all. As far as what prosecution entails, I'm not sure about that, but I don't want anything to happen, honestly, because I understand that the brand and what he has going on. I just wanted time to get away, which is what I've done now. So I'm safe. I'm out of the apartment. Next steps, like I would hope that, you know, he can sign, like I was told before by a previous officer, that he can sign his own signature for releasing on bond and then moving forward from there, since there's no issue with us being in contact with each other right now.
All right. Thank you, Ms. Thomas. I appreciate you coming to court and making this statement today. All right. At this time, I'm going to accept the state's recommendation for his bond. He's going to receive a $3,000 surety, broken down 2,500 count one, 500 count two. He is to have no further contact with the alleged victim in this case. He can return to the DeFore Village apartment one time with a member of law enforcement to ascertain whether or not the victim is there. If the victim is not there, he can return to that location and the stay away will not apply. He is to have no weapons, drugs, or alcohol as a condition of that surety bond, and he will be reset to the SAP calendar on August the 9th, whereby this entire case can be revisited. All right, is there anything further from either party?
Sorry.
Further.
Ms. Thomas, the best thing for you to do is if you have questions to contact his attorney, Mr. Bartels, who could answer specific questions for you, okay?
Yes, ma'am.
All right, thank you. Take care. Who do we have next?
Position 5. Oh, sorry.
All right. All right, we're going to the position Jalon Culver. All right, are you Jalon Culver?
Yes, ma'am.
Okay, your case number is 22 CR 004944F, and what you're charged with battery against a pregnant female and battery family violence, first offense with the offense date of January the 9th of 2022. Do you understand your constitutional right?
Yes, ma'am.
All right. Mr. Howard?
First.
All right, thank you. Ms. Duncan?
yes, Your Honor, this incident is alleged to have occurred on January 9th, 2022 at 515 Fulton Street Southwest, apartment 2409 in Atlanta, Georgia, Fulton County. The victim in this case is Shaquita Davis, SHAQUITA Davis, common spelling. Ms. Davis is the parent of the same child and other person living with the accused at the time of this incident. In this incident, officers responded to a dispute call, and when they arrived at the location, they were met with Ms. Davis, where she told the officers that her boyfriend, the defendant in this case, Mr. Culver, choked her. She also stated to officers that he choked her because he found some old love letters and became angry and wrapped his right hand around her neck. When she began to fight him off, she stated to officers that he struck her in the face and busted her top lip. She also stated to officers at the time of this incident, she was 4 months pregnant, and they had been living together since September of 2021. In this case, we are concerned about a risk of reoffense as the victim and the defendant have been stated to live together at this address. We also have concerns about intimidation of the particular witness. We did have an occasion to speak with the victim in this case. However, she vehemently denied wanting to speak to our victim advocate about this case at all. However, she did not confirm or deny any of the facts alleged in this case, given the circumstances involved in the violent nature of the offense. We have concern that there may be some intimidation there because if the math is correct, she might have recently just had a young child. Even though this is his first offense, we are concerned given the nature of the offenses. So we're going to be requesting a total of a $5,500 surety bond. That's $3,500 on the battery family violence and $2,500 on the battery against $2,000 on the battery against a person who is pregnant, if my math is correct. No further contact with the victim in this case, since we were not able to ascertain her wishes for contact, and out of an abundance of caution, we'd ask for a third-party child contact, a stay away, 1-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. Nothing further from the state.
All right, thank you. Mr. Bartels, this is your case. Please.
Yes, it is, Your Honor. I've spoken with Mr. Culver. As Mr. Howard indicated, he has no criminal history. This is his first arrest. He is 24 years old. He indicates that he's employed full-time. He works at the Waffle House. And he indicates that he has family in the Metro Atlanta area, including his mother and his brother. He does deny the allegations that are in the warrant. He indicated that he can stay with his mom during the pendency of this case. So I'm told that a no further contact order would not be an issue. And given all of that, we would ask that he be allowed to sign his own bond, or we would ask the court for an unsecured judicial release.
All right, thank you. I'm going to sound for Ms. Davis. Ms. Davis, if you are present on this Zoom conference and wish to be heard, this is your opportunity to speak. I'm sounding for Ms. Shaquita Davis.
Oh, boy.
All right, hearing none, Mr. Culver is going to receive a $5,500 signature bond through pretrial services. He is to take the 1-day anger awareness course. He is to have no further contact with the alleged victim, and he must stay away from the incident location. He is to have no weapons, drugs, or alcohol as a condition of that bond. Is there anything further from either party?
No, Your Honor. Thank you.
What is the
All right.
court's position on child contact if the child has been born?
Oh, if he can arrange to see the child through a third party. Third party
Okay.
contact. All
Yeah,
right.
break down that bond amount for me, please.
Just as the state recommended, but it's going to be signature 2,000 count 1, 3,500 count 2.
Okay, thank you, Judge.
All right, anything further? If not, best of luck to you, Mr. Culver, and your case is concluded at this time. We can move to the next position.
Position 6.
All right, are you Christian Horton?
Yes, ma'am.
All right, Mr. Christian, Mr. Horton, your case is 22 CR 004938C, in which you're charged with 1 count of battery family violence with the offense date of March 20th of 2022. Do you understand your constitutional right?
Yes, ma'am.
All right, Mr. Howard, will you put that his history onto the record? Thank you. All right, Ms. Falk, is this your case?
Yes, it is, Your Honor.
All right, Ms. Falk.
Your Honor, this incident happened back on March 20th, 2022. Officers responded to 1991 Delow Drive Southwest, apartment N201. When they arrived at that location, they spoke with Miss Tashayla Hall, that is Tashayla, last name Hall, common spelling. Ms. Hall stated that the defendant and the defendant, who is the father of her child, had gone to the store, arrived, slamming his car door shut in kind of apparent agitation. There was an altercation between the two. As she got up to feed their child, the defendant had gotten behind her, pushed her on her side. She stated the two of them ended up tussling with one another. The defendant then attempted to leave the location. At that point, Ms. Hall told him to take the child with him. He said no. Ms. Hall then stated to police that dropped the keys. She grabbed them and told him again to take their son with him. And at that point, the defendant began grabbing her around the neck and squeezing her in the living room. She stated the altercation then moved into the dining room kitchen area, where he again squeezed her around her neck, and officers were able to observe a small bruise to the left side of her neck, which was then captured on the body camera of the officers. At that point, the defendant then left the location. Although this is the defendant's first offense, we do have some concerns about the nature of this offense, the fact that it happened in the presence of a small child, and the fact that there is a intimate relationship between these two parties. We did have an opportunity to speak with the victim in this case, Ms. Hall, and she did state that there hadn't been any violence in the past, and she did confirm that the defendant did in fact grab her by the neck twice during this incident, but stated he did not apply a lot of pressure. However, that would be contradicted by the bruise that was seen on her neck. Normally, if no pressure is applied, you wouldn't see bruising to her neck. And also, she confirmed that the defendant slammed her head to the ground. That being said, she stated she was not afraid of the defendant. The state has some serious concerns about that. If you have a person who would take the mother of their children, bruise their neck, and then slam them into the ground. The state's recommendation on this case is a $4,000 surety bond. We are recommending stay away from Ms. Hall and no further contact with Ms. Hall, and stay away from the address located at Delow Drive. We are also requesting a one-day anger awareness, no alcohol, drugs, or weapons. Thank you, Your Honor.
All right, thank you. I'm going to hear from Ms. Davis before I go to you, Ms. Kim. Ms. Davis, if you'd like the opportunity to be heard, please please unmute your screen if you'd like to make a statement. You're not required to make a statement, but if you'd like to, this is your opportunity. Do you wish to make a statement? All right, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right, you put your hand down. I am most interested in whether you wish to have contact with the defendant, but otherwise, what would you like to tell the court at this time?
The incident between us was in March, and since then we have been good. We have had any altercations. We have had really no arguments. We've been good, and I am not afraid of the defendant. And yes, I will wish to have contact with him.
What did I say, Sam? Thank you.
Okay. All right. Is there anything else you'd like to tell me?
No, ma'am.
All right. Thank you.
Your Honor, if I may ask one question.
I'll let you speak. Let me let Ms. Kim speak, and then I'll both give you an opportunity to speak with that witness. All right.
Yes, Your Honor. Thank you.
All right. Thank you, Ms. Kim.
Yes, Mr. Horton is 22 years old, Your Honor, and actually they do not live together. He has a separate address that he has, and he has a 7-month-old baby with Miss Hall, and he's been here all his life. His parents, siblings are all here in Georgia, and he also has a job at Amazon as a full-time. He's been working there for about 1 year. He graduated from high school and he has some college experience. And Your Honor, this is the first one, and he is recommended for unsecured judicial relief by pretrial services. And we would like to request for signature on bond for him. And of course, no further violent contact as well. Thank you.
All right. Ms. Falk, I know you wanted to ask one question of the witness. You may do so at this time if you wish.
Ms. Hall, and is it correct that you had an opportunity to speak with our victim advocate today?
Yes.
And when you spoke with her, you did confirm what the state has said, that he did place his hands around your neck and slam you to the ground on this date.
Yes.
Thank you. Nothing further for this witness, Your Honor.
All right, thank you. At this time, Mr. Horton is going to receive a $3,500 surety bond. He is to have no further violent contact with the alleged victim, last name Hall. He is to stay away from that incident location. I am going to do that, even though I'm not orthodox. And he is to have no weapons, drugs, or alcohol as a condition of that bond.
Your Honor, can he have a one-time law enforcement escorted visit to have his personal belongings? And
Yes.
also a third-party transfer child visitation?
Yes, he can
Thank you.
third-party transfer the child and one-time return with law enforcement to get any items that he might still have at that location.
Thank you, Your Honor.
All right, best of luck to you both. Who do we have next? Is there anything further from either party?
No, Your Honor. Thank you, Your Honor.
All right.
Nothing further.
All right, best of luck to you, sir. Can we move to the next position, please?
Yes, position 10.
All right, I'm not gonna sound this charge for position 10. Mr. Robinson, your case number is 22 CR 004918B.
Judge,
Yes. Is someone crying? Are we all right at courtroom 2? What's happening?
Your Honor, it doesn't appear there's anyone in the seat.
There isn't. But I heard some crying.
Agreed. I did as well.
Very concerned.
can we move to position 11? No.
Is everything all right at courtroom 2?
Yes.
Okay, just making sure. All right, we're gonna go to position 11, Rico Robinson. Mr. Robinson, your case number is 22 CR 004941J, in which you're charged with loitering or prowling with the offense date of July the 26th. Do you understand your constitutional right?
Yes, ma'am.
All right, Mr. Howard.
56 total. He got a lot of FTAs. Last arrest was last month for probation violation. He's on probation for burglary. That's 14 SC 128071. In 2015, they gave him 20 years.
Okay. Okay, I think I've got a good flavor there. We'll go to Mr. Dudley. Mr. Dudley, can you begin by giving me the incident location?
Yes, Your Honor. This incident took place at 3210 Elkin Street.
Okay, I'm gonna have to recuse myself from this case. The alleged victim, I'm gonna state on the record, I had a feeling, that's why I asked you this. The alleged victim is my neighbor and friend. So this case on Elkin Street is gonna have to be reset till tomorrow's calendar, at which time the other judges will have to take care of this case.
Your
All
Honor,
right, go ahead.
the state completely understands. Do you mind giving the state a moment just to see the booking date on this case to make sure there's no?
Yes, but either way, there will be
I
no way
understand.
I could do it, Ms. Falk. My address is 5 houses down.
Okay, completely understand, Your Honor.
I'm open to, I do understand, you're right. I know that there are some concerns, but I cannot handle that case today. So we'll need to go to another position. Let's see. I'm gonna send a message and see if perhaps there's another judge who could step in just to do this one case.
He was arrested yesterday and booked yesterday, Your Honor. I don't believe it should present any sort of Riverside issues.
Okay.
Thank you.
All right. All right. Can we move to the next position, please?
Your Honor, right now, Mr. Robinson is the only one we have right now, position number 10, but Ms. McLeod is actually talking to Mr. Richardson as we speak.
Mr. Richardson.
Yeah, he said that he wanted to come to court, so I brought him down so he can come to
What
court.
about Mr. Scott? Is that a case we could do?
Yeah, we can do Scott.
Yes, just out of curiosity, position 13, Lazarus Watley.
There's an officer going upstairs to see Mr. Watley. So he'll be on shortly.
Thank you so much.
Thank you.
All right, we're prepared to go forward on Mr. Scott, Your Honor.
All right. This is Mr. Scott. Let's see.
Yes, ma'am.
I actually have heard, 1 second, please. Hold 1 second. Let's not release Mr. Robinson yet. I'm gonna see if there's someone who could hear that case today. I understand that there are no Riverside issues, but still, I've sent a couple messages out. Who do I have before me? This is Mr. Scott.
Yes. Yes, that is correct, Your Honor.
All right, thank you. Mr. Scott, I believe your case number is 22 CR 004955B. What is the charge, Ms. Falk?
Yes, Your Honor. The charge is simple battery family violence. In this case, the warrant states that on the 24th day of July, 2022, at approximately 8 p.m., the accused was seen on video recording taken by witness Isaiah Lewis, intentionally making physical contact in an insulting manner by using two closed fists to continually strike his son Omarion Holloman in the face, chest, and leg area while straddling Holloman. The warrant is signed July 24th, 2022 by the judge in the municipal court of the East Point, Georgia.
All right, thank you. Do you understand your constitutional rights, Mr. Scott? He's muted.
Yes, ma'am.
All right, Mr. Howard, can I have the history, please?
This is first.
All right, thank you. Ms. Falk? You're
This
muted.
incident happened on July 24th at the Hilton Garden Inn located at 3437 Bobby Brown Parkway. Officers responded to that location in reference to a fight. They met with Mr. Holloman, who is the victim in this case, who was 15 years of age, and Isaiah Lewis. Mr. Holloman stated that approximately 8 p.m., his father attacked him. Officers were able to look at the video recording that's taken by Mr. Lewis, the witness, that shows the defendant physically attacking Mr. Holloman. Mr. Holloman stated his father was upset because he went to the store downstairs in the hotel. Mr. Holloman further stated that this is not the first time his father has attacked him. When officers spoke to Mr. Lewis stated that when he and Mr. Holloman returned back to the room, Mr. Scott just began attacking, the defendant just began attacking Mr. Holloman. He stated he began to record the attack at that point. The officers did speak with the defendant. The defendant stated he was hitting his son because he disobeyed him by going to the store when he told him not to. The officers, when viewing the video, they saw the defendant striking the 15-year-old with a closed fist to the face, chest, and leg area. They also observed the defendant attacking Mr. Holloman inside of the hotel room by hitting him with two closed fists in the face, chest, and leg area. So the attack actually began in the hallway of the hotel room and continued inside the hotel room. Although officers did not see visible marks, they did place the defendant under arrest, due in large part to the video evidence and the independent witness. The state is recommending a $3,000 surety bond on this case, Your Honor. We do have some serious concerns. This was not discipline. Let's just be really clear about what this is. This is not corporal punishment. This is not discipline. This is not a smack across the bottom or even several smacks across the bottom. This is a grown man getting on top of a 15-year-old child and hitting him with closed fists repeatedly. That is not discipline. It is an abuse. And so, in the fact that Mr. Holloman stated that to police this was not the first time this has happened to him, gives us some serious concerns about what is happening in this household to this 15-year-old child. And for those reasons, even though the defendant does not have a history, as you know, just because someone does not have a history doesn't mean things aren't going on behind closed doors. We are asking for a $3,000 surety bond. We are asking that there be no further contact at this time. I don't know if their DFAX was called out to this location, but I would ask if there is a DFAX plan in place, the defendant follow any DFAX plan that is in place. And we are also, that we don't need to stay away from the location. However, we are also asking for no alcohol, drugs, or weapons, and one-day anger management. I believe that is needed in this situation.
All right, thank you. What was the stay away address again, Ms. Falk?
Well, we didn't ask for a stay away from the Hilton
Okay.
Garden Inn, so
Okay.
there is not a stay away address in this.
All right, thank you. I'm sounding for Mr. Holloman if he's present on this Zoom conference and wishes to be heard. Mr. Holloman, if you are present and wish to be heard. All right, Ms. Kim.
Oh,
Go ahead,
Your
Ms.
Honor,
Falk.
I'm sorry. The state will just say we have had our victim advocate, because there was a little bit of short notice on this, trying to get in touch with Mr. Holloman. But again, we are talking about a 15-year-old, so it is going to be a little difficult.
All right, thank you. Ms. Kim?
Yes, Your Honor. Mr. Scott is 51 years old, and actually he was visiting here from South Carolina, where he resides permanently. It's about 3.5 hours. He and his fiancée and fiancée's child and Mr. Scott's child, complaining witness here, they drove here to help fiancée's daughter to move from Georgia to South Carolina. And they have Mr. Scott has total of 4 children, and 3 of them are all grown up. And Mr. Hallman is only one minor child, and they are on the way to get married with a fiance. I mean, Mr. Scott is, and Mr. Scott has been disabled for the last 3 years. So there is no other income except very little bit of disability check that he gets. And also he has high school education. He resides we have a good address in South Carolina and good telephone number. And it's only about 3.5 hours. He's willing to drive to come to the court. And this is his first offense. And he says that he was not really, there was no visible mark on Mr. Hartman, and it was not physical abuse. He denies that allegation. We would like to request for a signature on bond, and that's it, Your Honor. Thank you.
All right, at this time, I'll be accepting the state's recommendation. He will receive a $3,000 surety bond, and he is to have no further contact with the alleged victim, last name Hartman, and he is to have no weapons, drugs, or alcohol as the condition of that surety bond.
And Your Honor, just to put the victim's name on the record and just spell that out, it is Omarion, Omarion, and his last name is Hallman. That's Hollman. LLMON.
All right, just to make sure, we're going to sound for anyone last name Hallman, just to make sure. All right, hearing none, I believe that will conclude Mr. Scott's case. Best of luck to you, sir, if there's nothing further from either the state or the defense.
Your Honor, was that a $3,000 surety bond?
Yes.
Okay, thank you.
All right, who do we have next? Best of luck to you, sir.
Thank you, ma'am. Next, we can go to position number 10, Mr. Miles Robinson.
Okay, this is the case where I'm not going to sound the charge. Mr. Robinson, your case number is 22 CR 004918B. I'm not going to sound that charge, but I'm sure you're aware of the charge against you with the offense date of July the 26th. Do you understand your constitutional rights?
Yes, ma'am.
All right, Mr. Howard.
11 total. Last was 2019 probation out of Clayton County. He's on probation, felony obstruction. 2019 possession of drug-related objects conviction. He got probation violation 2018. It's for obstruction to enter an auto. 2017, another probation violation. Trespass NOLO from 2016. 2016 probation for entering vehicle. 2016 simple battery family violence NOLO. 2015 entering auto, first offender. What's up?
All right, thank you. All right, Ms. Falk?
Your Honor, without getting too much into the facts of the case, this occurred on July 26, 2022 at 2848 Main Street in East Point, Georgia. The victim on this case is Shanlevia Barber. That is SHANLEVIA Barber, BARBER. Ms. Barber appears to have been waiting at the MARTA station platform when the defendant approached and placed his hands on her. The state will just say it does not appear that these two know each other, that they have any sort of relationship which would cause the defendant to feel this comfortable with her. I will say that there was the 2016 simple battery case. A probation violation, I think, was the 2019 probation violation. The state's recommendation on this is a $2,500 surety bond, no further contact with Ms. Barber. We are asking for a stay away from that MARTA station in East Point at 2848 Main Street. Your Honor, the state will just comment that the defendant, seems to have an issue with keeping his hands to himself. There was that 2016 simple battery and now this case. And I just think we need to send a very clear message when it comes to individuals who engage in this type of behavior, that it is not appropriate, it is not wanted, and that it does cause people to feel very uncomfortable when it happens. And so the state is asking for that recommendation.
All right, I'm gonna sound for the alleged victim before I go to Ms. McLeod. If Ms. Barber is present on this Zoom conference and wishes to be heard, this is your opportunity to do so. You are not required to make a statement, however, but you have the ability to if you'd like to do so. Okay, hearing none, Ms. McLeod, please proceed.
Yes, Your Honor. My client is 23 years old. He tells me that he has been having a lot of issues since he lost his sister last year. It seems that, Your Honor, my client has some challenges with his mental health that he's been dealing with for some time, and it appears that he's just fallen through the cracks, that he has been arrested on several occasions and nobody has looked into this aspect of what is happening to him. He admits that this incident happened. He does not, of course, know the alleged victim, and he just doesn't really have an explanation for it. I just, based on my discussions with him, Your Honor, I think he does need mental evaluation, and I was wondering if the court would order that. He's not in a position to pay bond because he is essentially homeless, he tells me.
And Your Honor, the state joins Ms. McLeod in a request for an MHET if she believes that one is necessary.
All right, at this time, I'm gonna order the $2,500 surety bond just to make sure we can actually get that MHET done. He is to have no weapons, drugs, or alcohol and no further contact with the alleged victim in this case. And he must also stay away from the East Point MARTA station as a condition of that surety bond. He will be reset to the SAP calendar on August the 9th, whereby this can be revisited.
Thank you.
Anything further from either
Nothing further,
party?
Your Honor. Thank you.
Nothing further, Your Honor.
All right, best of luck to you, Mr. Robinson.
I
No, Mr. Robinson, I don't want you to say anything to me. The state is listening and anything you say can be used against you. Okay, so if you have a question, please call Ms. McLeod. She can assist you, all right? All right, who do we have next?
We got position number 9, Mr. Daniel Richardson.
Okay. All right, Mr. Richardson, Your case number is 22 CR 004943G, in which you're charged with one count of simple battery with the offense date of July the 19th. Do you understand your constitutional rights?
Yes,
Okay, thank you. Mr. Howard?
7 total. He's a resident of Florida. Last arrest was 2020 for vehicle theft. He just said charges were amended. This was out of Florida, West Palm. 2017 probation violation. Fraudulent use of personal identification. Yeah, hold on. Hold on, Judge. Man, how many pages is this? That was from 2016. So it's a robbery, carrying concealed weapon, grand theft, altered instrument, stalking. All of those fall under one arrest. I got a 2012 assault. I'm not gonna call it out loud. It's similar to what the last guy was.
Yes, I understand the essence of what you're saying. I understand. Okay.
That's it. This is first Georgia arrest.
Okay. All right, Mr. Dudley.
Yes, Your Honor, this incident occurred on July 19th, 2022 at 80 Anderson Avenue in Atlanta. The victim, Charlene Greer, CHARLENE, Greer, GRIER, stated that she was on the bus at the Westlake MARTA station. And as she was getting up to get off the bus, she stated she was pushed off of the bus by the defendant. This appears to be an unprovoked attack, as the defendant does not know the victim, to my knowledge. Now, the state recommends a $3,000 surety bond, no further contact with the victim, a stay away from the MARTA address, and no alcohol, drugs, or weapons while out on bond. Nothing further from the state.
All right, I'm gonna sound for the alleged victim, Ms. Greer. Ms. Greer, if you'd like the opportunity to be heard or you'd like to make a statement at this time, this is your opportunity to do so. All right, hearing none, Ms. McLeod.
Yes, Your Honor. My client is 25 years old. He tells me that he moved to the state of Georgia from Florida quite recently, actually, about a month ago, because things had not been going very well for him in Florida, and he'd lost a family member. So he decided to move to Georgia for a fresh start, essentially. He tells me that what happened was that the alleged victim was on the bus causing a disturbance and being belligerent with a number of people. He said something to her about her behavior and she pulled a weapon on him. And that was what started the whole thing. And when she stepped off the bus, because she had pulled the weapon on him before she stepped off the bus, apparently she called the police. He told me that he explained to the police officers what had happened and that she had pulled a weapon on him. He says that the police officers said that there was a video, and he believes that based on that, there should have been a video of her pulling a weapon on him. He maintains that she was the aggressor, Your Honor. This is stranger to stranger. They do not know each other. It was just caused by an incident that happened on the bus where she pulled a weapon on him.
All right, thank you.
He's not working, Your Honor, he tells me, and he's currently homeless.
All right, at this time, Mr. Richardson's going to receive a $1,500 surety bond. He is to have no further contact with the alleged victim, last name Greer, and stay away from the incident location on Anderson Avenue. He is to have no weapons, drugs, or alcohol. And he will also be reset to the SAP calendar on August the 9th, whereby this can be revisited. Anything further from either the state or defense?
Nothing further. No.
All right, best of luck to you, sir. Who do we have next?
Your Honor, we can go to either 5 North or South Annex, but do we still need to hold on to Rico Robinson.
Mr. Robinson will be reset. I attempted to find a judge who could hear that case today, and I did not receive any response. So because I did want to note on the record, though, that I am unable to hear Mr. Robinson. I don't believe I'm sitting tomorrow, but in the event that I am, we will have that same problem. So I'm noting my personal conflict, but inability to hear that case.
Your Honor, the state would make a request if you are sitting tomorrow, if there can be arrangements to have a judge hear this one case to ensure that we don't have any issues going forward with timeline.
I don't anticipate being here, Ms. Falk, but you never know. And you know, if that does happen, I will see if Judge Mincy could hear that one particular case. I was hoping she could hear it today, or Judge Law, but I have not received any messages, so we will have to reset that case.
I appreciate your efforts, Your Honor. Thank you.
All right.
Okay,
All right.
We're done here in courtroom 2. May we be excused, Your Honor?
Yes, courtroom 2 can be excused. Have a great rest of your afternoon.
Thank you.
All right, we'll go to the South Annex and 5 North. Have you all heard your constitutional rights? Were you logged on since the beginning?
Not South Annex, Your Honor.
All right, I'll repeat the litany. All right, all defendants, please pay attention. You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have a right to an attorney at this proceeding. This particular proceeding is being broadcast over the internet as a live stream. It is also being recorded. That means that any member of the public can log on and watch this particular proceeding. All right, who do I have first?
Position number 8.
All right, are you Cherish Okafor?
Yes, ma'am, I am.
All right, your case is 22 CR 004939E, on which you're charged with 1 count of theft of service with the offense date of July the 26th of 2022. I want to advise you, you have an absolute right to remain silent. I advise you of your rights. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard.
6 total. She's a resident of what is it, Houston? Yeah, Houston, Texas. Last arrest was 2021, giving false information. Was dismissed. She had a 2020 assault causing bodily injury, DV. That was a conviction. A trespass dismissed from 2017. 2017 assault causing bodily injury. I think that was a conviction. And before that was 2016 trespass. That's it. And that was dismissed.
All right, thank you. Mr. Dudley?
Yes, Your Honor. This incident occurred on July 26, 2022 at the Taco Mac in Prado Shopping Center at 5600 Roswell Road, F210 in Sandy Springs. The defendant entered Taco Mac and ordered food while knowing that she did not have any money or a way to pay for her food. After eating, the defendant went into the bathroom to change into clothes that she had shoplifted earlier to attempt to disguise herself. She was confronted by the restaurant staff before being able to leave, and she remained in the restaurant until the police arrived. Once the police arrived, the defendant told Officer Jay Redke that she arrived in the Atlanta area from Texas a few days before the incident. She stated that she does not have housing, a job, family, or friends in the area. She also stated that she has done this before and has been arrested for this before. The state recommends a $1,000 surety bond, a stay away from the incident location, and no alcohol, drugs, weapons while out on bond. The state makes this recommendation because there is a concern for risk of reoffense, as she stated she has done this before and has been arrested for this before. There's also a concern that the defendant may be a flight risk considering her lack of community ties. She just came to Atlanta. She has no home, no job, family or friends, nothing tying her here. And she is from Texas as far as a couple of weeks ago. And the bulk of her criminal history is from Texas, Your Honor. Nothing further.
Thank you, Mr. Dudley. Ms. Kim?
Yes, Your Honor. Ms. Cherish is 24 years old, and she moved from Texas a few days ago because of her dream to be more independent here in Georgia. She believes that she will have more opportunities here in Georgia. And even though her mom's side reside in Texas, her being 24 years, she does not think that she should be relying on the family. So she chose to come here and she wants to stay here, and she wants me to recommend social worker services so she can get housing resources and start applying for, job and getting a job and eventually getting a car. That's her plan and dreams and goals right now. She has been, she graduated from high school, and that's about it, Your Honor. 24 years, and this happened for $59.20. Currently, there is $500 surety bond. We would like to request for signature on bond. However, if Your Honor is not inclined to give her signature on bond, we would like to request that $500 surety bond remains the same. Most of trespass cases were all dismissed, and I think that's something that we can do. Thank you.
All right. All right, at this time, Ms. Okafor will receive a $2,000 signature bond through the jail. She cannot return to the incident location by any means. And Ms. Kim, if possible, despite the signature bond, I'm hoping that you can still give her social worker services.
Yes, Your
Please
Honor.
do your best to do so. She is to have no alcohol, drugs, or weapons as a condition of that signature bond.
Thank you.
All right, best of luck to you. Don't go
Thank
back
you.
there and don't do that again, ma'am. That
You're
will
right. Was
conclude.
that through the jail?
Yes, through the jail.
Okay, that'll be off the South Annex, Your Honor.
All right, have a great afternoon. Take
You
care.
too, ma'am.
All right.
13.
All right, have you all heard, has he heard his right?
No.
Okay. All right, Mr. Watley, your case is 22 CR 004940J. I'm Judge Melanie Williams. You're charged with 1 count of theft by taking a misdemeanor with the offense date of June the 4th of 2021. You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have a right to an attorney today. And this proceeding is being broadcast over the internet as a live stream. It's also being recorded. That means that any member of the public can log on and watch this proceeding. Do you understand your rights? All right, Mr. Howard?
Can you hear me?
Yes.
June 2021, shoplifting out of Dunwoody. June 14th, 2021, theft by taking, entering auto. June 20th, 2021, theft by taking. September 2021, simple assault. So he's been in Fulton County Jail since 2021.
Okay.
Warrant for purse snatching. I don't know if that's part of one of the theft by takings or what. But the date of the purse snatching warrant is July 26, 2021. So, that's it.
Okay. All right, Ms. Falk?
Your Honor, I know that you are probably doing the math in your head, as I had to as well. This defendant has been in for over 400 days. This warrant was taken out about a month after the defendant's arrest. The defendant's history is abysmal. There's no way around that. However, due to the clear administrative issues here, the state is compelled to offer a $3,000 signature bond on this case due to the extenuating circumstances involved with this case. The state is also going to recommend, in addition to that signature bond, that the defendant stay away from, have no further contact with the victim on this case. If you'll just give me a moment, I can pull up her name. Your Honor will just give me one moment. The victim's name on this case is Miss Cortez, Cortez. First name is, and I apologize for how I'm about to pronounce this, Itzel, which is Itzel. We are also asking that the defendant stay away from Marshalls located at 2625 Piedmont Road. Essentially what happened in this case, Your Honor, is Miss Cortez stated her Fila book bag had been taken from her. A black male had come up and snatched her red and blue Fila book bag. Inside of her book bag was United States currency, a work check, and some shoes. She was able to describe the defendant, and officers were able to see video surveillance of the suspect that shows him grabbing her book bag and then running. And he ran up the street away from the scene. This defendant does have 2 open and pending indicted cases in the DA's office, which is what has been holding him for this amount of time. So the state understands that although we are compelled to offer a signature bond in this case, that it will not allow him to get out due to his 21 SC 179807 case, as well as a hijacking motor vehicle case that is also pending in the superior courts. That is all.
All right, Ms. McLeod, your position regarding the signature bond.
I am not opposed to the signature bond, Your Honor. My issue is that this child, and he was a child at the time they incarcerated him, has been sitting in Fulton County Jail for over a year. He was I don't think he was quite 17 when he was arrested, locked up all this time. All the alleged issues that he has, they were all within a very short period of time. So nobody seems to have taken a look to find out what was going on with this child and to see if something could be done for him. I do not see the benefit of having someone this age locked up for 13 months. He may have what the prosecutor describes as an abysmal history. We have to understand that this young man was a child when he was arrested. And if all of these things happened around the time, somebody should have taken a look at him and tried to help him. Having him sitting there in Fulton County Jail with adults is not going to help him at this time, Your Honor. At first, I did not believe him when I heard that he had been sitting there for 13 months, a child.
Court is inclined to agree with some of what you're saying, but this case will no longer be holding him in action. Perhaps may be taken shortly hereafter. He's going to receive a $3,000 signature bond for the jail. I am going to order that he stay away from that marshals and have no contact with the victim. Last name Itzel, and have no weapons, drugs, or alcohol.
His mom is actually in the Zoom, Your Honor.
Your Honor,
right.
I just want to make one thing clear, and I'm sorry.
I think we all know this is a problem, Ms. Falk, but very, very briefly.
I will be very brief. This warrant was located yesterday. So this warrant has not been holding him in for 400 days. What's been holding him in for 400 days is the 22 SC case where he's got hijacking a motor vehicle. The SG's office and the DA's office are 2 separate entities run by 2 different elected officials. So I just want to make it clear on this.
I think we know that, Ms. Falk, I think we understand that there's something did slip through the crack, but we also understand that this is not the reason entirely that the defendants, there's some issues on both sides. Let's just put it that way. But
I'm going to contact the DA's office to speak about this child locked up in jail.
And I think that'd be fine, Ms. McLeod. I think you should do that. But this case will no longer be holding him in, and it appears that it was just discovered recently. So $3,000 signature bond for the jail with the conditions listed. All right. Best of luck to you, Ms. North. Do not go back to that store. All right. I understand we've waived appearance. So for position, was it 9, Ms. Kim? No, it was not 9, 7. So we'll go ahead and do position 7, and the jail can be excused. Ms. Kim, have you already submitted your waiver?
Yes, Your Honor.
All
And
right.
I received from Ms. Middlebrooks that she received my waiver.
All right, perfect. Mr. Howard, can I have the history for position 7, please?
You gonna put it on the record, or you want me to go?
I'd like you to go, Mr. Howard. I'll put it on the record. And then when I give my announcement, I was trying to be expeditious.
All right, give me a minute. Let's see. 1, 2, 3, 4, 5. 5th arrest. Last arrest was October. Criminal trespass, damage to property. 2010 out of Florida for failure to appear. 2010 fugitive. and a 2009 fade to appear out of Florida.
All
That's
right,
all I have.
thank you. Mr. Dudley?
Sean, this incident occurred on July 26, 2022 at 2848 Main Street in Atlanta, Georgia. The victim, Naele Ariando, excuse my pronunciation, but the spelling is Nayeeli for first name, last name Arredondo, was aboard the bus and sat near the bus operator. The defendant came and sat right next to the victim. When the bus got to the victim's station, she tried to get up to get off of the bus, but the defendant did not move. The defendant then stood up and hit the victim in the head with her fist. This incident was witnessed by Nash Dwight, and it appears that the victim and the defendant do not know each other. This was an unprovoked attack, and the state recommends a surety bond of $3,000 with the conditions of stay away from MARTA, no further contact with the victim, and no alcohol, drugs, or weapons while out on bond.
All right, I don't believe this victim is online, but I will still sound for the victim, last name Arredondo. All right. I don't see that victim, so we'll go to you, Ms. Kim.
Yes, Your Honor. Miss James is 62 years old, Your Honor. And of course, they don't have any relationship. However, she has a permanent address that we can send the notice of hearing to. And she is indeed recommended for unsecured judicial relief, signature on bond by pretrial services. So we would like to recommend for signature on bond. She seems to have, this is just one-time thing that just happened. So signature on bond, Your Honor. Thank you.
All right. In the case of Angela James, 22 CR 0049278, in which she's charged with simple battery with the offense date of July the 26th of 2022, the defendant is going to receive a $2,000 surety bond. She is to have no further contact with the alleged victim, last name Arredondo, and to stay away from MARTA. And she is to have no weapons, drugs, or alcohol. The case will be reset to the SAP calendar on the 9th, whereby this can be revisited.
Your
Anything
Honor,
further? Yes.
can she have a stay away from just one MARTA station?
She was in the one MARTA station. Let me clarify those facts. I don't necessarily have a problem with that. Miss Kim, Mr. Dudley, what was the MARTA station she was in? I understand that the state is requesting all of MARTA, but I just would like to clarify that.
East Point, I believe,
Yes,
Your
East
Honor.
Point MARTA station.
All right, what I'll do is she's to comply with any active suspensions if she has them, and to stay away from the East Point MARTA station.
Thank you, Your Honor.
All right. I believe that concludes our entire calendar. Ms. Middlebrooks, will you please review it for me?
What happened with number 4?
Medical reset.
And a
Number
transfer.
4 was
to the
transferred to
DA's
Superior
office.
Oh,
Court.
transfer, that's right. Transfer.
Yeah, I wanted to clarify, number 4 is a transfer to Superior Court?
Yes.
Yes.
Okay, thank you. Okay.
Your Honor, the plea paperwork was received by Ms. Middlebrooks.
Wonderful.
Position number 1 is a $1,000 good bond, reset SAP August 9th. Position number 2 was a plea. Position number 3 is a $3,000 good bond, reset SAP August 9th. Position number 4 was transferred to Superior Court. Position number 5 is a $5,500 sign-on bond through pretrial, reset further notice. Position number 6 is a $3,500 good bond, reset SAP August 9th. Position number 7 is a $2,000 good bond, reset SAP August 9th. Position number 8 is a $2,000 sign-on bond through the jail, reset further notice. Position number 9 is a $1,500 good bond, reset SAP August 9th. Position 10 is a $2,500 good bond, reset SAP August 9th. Position 11 will be reset to SCA 728 tomorrow. Position number 12 is a $4,000 sign-on bond through pretrial, reset further notice. Position 13 is a $3,000 sign-on bond through the jail, reset further notice. On the add-on calendar, there's a $3,000 good bond, reset SAP August 9th.
Any comments, changes, corrections, or questions?
No,
All right,
that is it.
All right, hearing none, we'll be in recess until tomorrow, July the 28th at 2 p.m., at which time I believe Judge Law will be presiding. Everyone take care. Have a great rest of your afternoon. Bye-bye.
Thank you,
Thank you.
Judge.
You
Have a
too.
good day. Good to
Bye,
see you.
thank you.